There we go. All right, so welcome everybody. I'm glad that you joined us tonight. I'm happy to provide you with some information this evening about the Summer Village of Bondiss Municipal Development Plan and Land Use Bylaw review process. So the purpose of the meeting this evening is to provide you with an overview of the draft new municipal development plan. The Summer Village has never had one before, so this is a brand new document for the Summer Village. And then talk to you a little bit about what a land use bylaw is, why the Summer Village has one and has to have one, and provide you with an overview of some of the more significant changes. As we go through, we'll talk a little bit about what the process has been for developing those documents. And then when we get to the end of the session tonight, we'll talk about, we'll provide you with the opportunity to give us with a little bit of feedback too. Your preliminary thoughts, I guess. Our assumption this evening is that you haven't necessarily had the opportunity to review the documents in detail. So we won't be putting you on the spot unless you have had the opportunity to review the documents in detail and you have some specific questions that you'd like us to address. So either of those scenarios will work for us, but our intention and the focus this evening is to try and give you a high level overview of those changes to provide you with some direction as you're undertaking your own review of the draft documents. So the purpose of this project has been to assist the Summer Village prepare their very first municipal development plan. And the reason that the Summer Village has undertaken that particular project is that all municipalities in Alberta are now required to have a municipal development plan. Prior to 2017, I think it was only municipalities with a certain population were required to, I think it was 2,500 people, have a municipal development plan, but now all municipalities, even the little ones like summer villages, are required to have one. And so this was a box that needed to get checked in order to ensure that your municipality was current with and up to date with the requirements in the applicable legislation. And then the other part of the project, I think equally or perhaps even more important, was updating or modernizing the Summer Village's land use bylaw, which was an older land use bylaw. It had been amended a few times, and it was time to address some of the challenges with that document that was making it difficult to use, I think, for members of the community, difficult for the Summer Village to consistently interpret and apply, and then make it a little bit difficult to utilize as a tool for enforcement in situations where there were things going on that were causing problems for people within the community. So that was what the intention was with the document at the onset. I mentioned that our meeting tonight is to provide you with an overview of the drafts. And the reason we went with this format instead of an in-person format is because we recognize that for many people, the Summer Village is a recreational property. It isn't necessarily the place that they live full time, although it is for some of you. And we wanted to make sure that we were providing the best forum or greatest opportunity to have as much participation as possible from members of your community. So I know some of you know what a municipal development plan is, but I'm going to, for the benefit of those of you who haven't had to work with one of these documents before, provide you with a high-level overview of what it is. So a municipal development plan, or MDP, is a statutory plan that's a mandatory plan for all municipalities in the province. You guys, as I mentioned, currently don't have one. They're generally the primary land management tool for municipalities. So they provide really high-level goals, objectives, and policy direction to help the Summer Village plan for what types of developments you'd like to see within your boundaries and what types of infrastructure you need to support those developments going forward. In summer villages, the scenario that's most, I guess, desirable most of the time is planning for and enabling and ensuring that your planning documents enable just about the status quo. So identifying what the specific character of your community is and establishing a framework to ensure that going forward that character of the community is retained or maintained is generally one of the focuses of these types of documents. It also is a document that I think is really valuable in summer villages because summer villages being so small, you don't have a lot of available at the local level environmental data or site suitability data. Yeah, summer villages regularly don't have a GIS mapping program that administration can rely on, and you know, a whole slew of staff to assist in the assessment of different types of applications. So when we're working on municipal development plans for summer villages, a large part of what we're trying to do is some data collection and analysis to provide some information about the parcels within the community that help to guide and enable the development authority to have the information that they need to determine site suitability in the event that lots develop or redevelop within your community. So it's a tool that's useful from that perspective for summer villages, even though we're anticipating that the growth scenario that's going to be most desirable is one that is pretty close to the status quo. So in taking that data and establishing some goals, objectives, and policies, the municipal development plan will help the summer village establish a vision for land management and development to help guide council and to help guide the development authority primarily when development proposals come forward. So municipal development plans all have to address some things. These requirements are established in the Municipal Government Act, which is that piece of legislation that not only enables, but I guess requires municipalities to have this type of a plan. So they have to address future land use. They have to address the manner and proposals for future development. They have to talk about how the municipality will work with their adjacent municipalities and how they will provide municipal services and facilities. The policies in the municipal development plan have to be compatible with the subdivision and development regulations that apply. And then policies have to address the provision of MRs, municipal reserves, and MSRs, municipal and school reserves, which are types of reserves that are due at time of subdivision. So even when you're a small municipality like yours, and we're anticipating that there will be little, if not no, subdivision in the future, we still have to include policies that address these matters. And they also have to provide some policy direction that talks to the protection of agricultural operations, which is another one of those things that seems kind of silly in the context of a summer village, but it's a requirement in the legislation. So as you're going through the municipal development plan, you may wonder why some of these things are included, considering the size of and focus of your community. And some of those things are there because they have to be. So the other thing that's important to note is you do have an intermunicipal development plan with the county, and the policies in the MDP have to be consistent with the policy direction that was agreed to as part of the negotiations of the development of that intermunicipal development plan. The Municipal Government Act also identifies a bunch of other areas that a municipality can include policy direction for in their MDP. Some of these make sense in larger municipalities more so than in smaller municipalities. I would suggest that addressing municipal infrastructure, environmental matters, development constraints, and conservation reserves are all really important or relevant considerations of even small municipalities like summer villages. Economic development and the physical, social, and economic development of municipalities is perhaps not quite as strongly identified within this draft MDP because you don't have commercial industrial sectors within your community. So we tried to focus on those areas that would be most relevant to your community. And the ones that I think are most impactful for you relate to provision of infrastructure, environmental matters, and then identifying potential development constraints that could impact the types of application requirements you would be required to provide with a new development proposal, or would impact where development could occur on a lot. So they are pretty broad in scope. In this case, as in all municipal development plans, we try to refine them to ensure that they're only addressing those matters that are most pertinent to the community, while still addressing those matters that we're required to address through the legislation. So you've got your municipal development plan, which is the higher level, future-oriented land use plan. It talks about your vision, goals and objectives. And then you have your land use bylaw. And similarly to the municipal development plan, all municipalities in Alberta are required to have one. The biggest difference, I think, between the two documents is that one of them is this higher level tool that does have policy direction that's binding on decision makers, but is intended to be future oriented. The land use bylaw is kind of like your rule book or your toolkit for helping you achieve the vision and the goals and the objectives that are identified within the municipal development plan. It has the site-specific regulations that identify how development and what types of development can occur on all of the lots within your municipality. So all land use bylaws establish processes for subdivision and development applications. So what will be asked for, how they will be processed, and they're guided by the requirements in the legislation. They provide information about how notice will be provided, how enforcement will occur when there's a development that occurs that contravenes the land use bylaw, and they provide some information about the appeal process. Land use bylaws also establish regulations for specific and general types of development that are enabled through the land use bylaw. So they let you know what you can build and what you can't build, and where and how they can be located on lots. And then they divide the municipality up into different districts and identify within those districts lists of uses that are permitted and those lists of uses that are discretionary. The most significant difference between the two types of uses is that permitted uses are allowed by right, and they have very, very limited appeal rights for adjacent landowners. Discretionary uses can be approved or not approved, depending on whether or not they're appropriate in the location that they've been proposed. It is rare for a discretionary use to not be approved, especially in a community like yours, but it is a distinction that's worth pointing out. Additionally, discretionary uses are appealable by anyone who claims to be adversely impacted by the decision. So there's a much broader range of appeal right for those uses that are identified as discretionary within a district. Your land use bylaw right now, the one that's in effect, was adopted in 1998. So it's an old land use bylaw. They really should be revisited every 10 years at the longest, even summer village land use bylaws. And that's because even if you don't have a ton of development pressure, the types of development that occur over a 10-year period change. And that's certainly been the case over the last 15 years, coming up on some instances 20 years. The types of things that we're getting inquiries about and the types of just even development designs that we're seeing are not things that are contemplated in your land use bylaw. And that makes it difficult to regulate those things and figure out if they're allowed or not allowed, and to manage some of the offsite impacts with some of those types of uses. We just didn't even think about them in 98. And now it's time to adjust and refine the bylaw to deal with those types of new changes and new types of developments. Additionally, there's been a number of changes to the legislation as it relates to municipal development plans and land use bylaws. And your land use bylaw hasn't been updated yet to reflect those changes. And they're significant. Some of them relate to things like the appeal process. There are changes to the mandated or legislated timeframes for different parts of the subdivision development and appeal processes. And those things need to be included in your land use bylaw to improve transparency and to ensure that your planning documents are consistent with the requirements that are identified within the legislation. So in the absence of them being in the land use bylaw, administration is still bound by what's in the legislation. It's difficult for the community to understand what's going on if the wording in the document that you look at is inconsistent with the wording in the document that is guiding the decision makers. So all of that is being updated and has been updated in the draft document to improve consistency and transparency throughout. The other thing to note, I guess, is that the land use bylaw approved in 98 didn't take into consideration an intermunicipal development plan or the draft municipal development plan because they didn't exist. So in order for it to be a really effective tool, it ought to, and it's required to, be consistent with those other higher level plans. And so some changes were required to ensure consistency between the goals, objectives, and policies in those documents and the tools that are established in the land use bylaw. So how do we get to here? The project's been going on for a little bit of time, longer than council would like, I think. The first newsletter went out to the community in June of 2022. So it's, I think, when we started in earnest, although there was a bit of a lag in the middle between then and now. Um, the community, that's when the community engagement began. There was a survey that went out, and we had 46 responses. So thank you to those of you who responded to that survey. It was very beneficial, I think, for council to hear some of your preliminary thoughts about land use and development within your community. All of the feedback that we heard during that part of the process was compiled and put into a report that was shared with council and administration, and it's, I believe, posted on the Summer Village website too. So if you have any interest in reading that, that is publicly available to have a look at. Uh, Once we started meeting with council in 2022, we met with council and administration, and we had a number of different meetings to gather information and to gain some feedback from council and administration to ensure that our work plan and then the directions that we were going in with the document were appropriate for your community. Our company works with summer villages and towns and counties. We do a little bit of work for the government of Alberta and a little bit of work for watershed associations. But we always, all of the work that we do is this type of work associated with municipalities. So we're always on representing municipal voices rather than a developer voice. And we work with about, I don't know, what are we now? I think maybe over 80 different municipalities throughout the province. And we recognize that each one of you is very different and unique. And these documents need to recognize the things about your community that you value. So there's some aspects of municipal development plans and land use bylaws that are consistent across different municipalities out of necessity because of the legislative requirements. But there's other parts of the documents that need to reflect you and your built environment and some of the environmental constraints and opportunities that exist because of the location of your community. So one of the things that we do when we're working on summer village municipal development plans and land use bylaws specifically is we work with a firm called CPP Environmental. And one of the first steps is to have them prepare a shoreline and aquatic assessment, which is, it's almost like a biophysical light for anyone who is familiar with those types of processes. They go out, they actually did an assessment from the water of the shoreline to identify areas where the riparian lands adjacent to the water were impacted. And then they identified the inlets and the outlets around your community and areas that would be environmentally sensitive or significant in terms of biodiversity, and then areas where the lands would be particularly sensitive in relation to the job and function that they do to protect the water quality of the lake. And they put together a report and some mapping that identified those areas that we were able to utilize to ensure that the policy direction and the land use bylaw was enabling developments that were appropriate for those locations and those features within your community. And we had some data to support what types of development to allow and what types of design mitigations might be important to ensure that development occurring within your municipality is having as low an impact as possible on your lake water quality. Because for the most part, I think the majority of you that are property owners at the lake are there because of the lake. There's other reasons that you're there too, friends and family, but the lake is a pretty important thing. And so when we're revising land use bylaws in lake communities now, we want to use some data to support different types of approaches to development design to minimize negative impacts on the lake environment. So that's one of the things that was done as part of this process. And that report was utilized to give us some very specific information about your community to help inform those recommendations. So there was the environmental data that was collected. There was the first steps of the public engagement. And then we brought that information back to council and prepared some draft documents, which we then reviewed with council and administration. The draft documents were updated a couple of times to reflect the input from council and administration. In preparing for our meeting tonight, I noted some other areas still that need to be revised in order to ensure greater consistency and improve interpretation. One of the things relates to the definition of boathouse, which I'll talk about in a few more slides. But there's those refining and altering and changes to the document documents are things that we need to do before we get this back to council for consideration and first reading. And we're hoping that as you do your review of the documents, you'll identify some of those things for us too, to ensure that the documents are the right documents for your community, and they'll enable you to use and enjoy your property in the way that you dream of doing, right? So now I want to get into an overview of the documents themselves, and we'll start with the municipal development plan because that's the higher level document. And I'll take you through the different sections and give you an overview of what's in those sections of the document. Oops, too far. So the document begins with a purpose section that just talks about what an MDP is. And it also provides some guidance regarding how the municipal development plan has been set up to ensure that it satisfies the requirements in the MGA. The next thing that is in the document is a statement about the plan principles. So there's 5 plan principles that guide the document. The first one is that land use and development will respect and maintain the local heritage and character of the community. The second is that in fulfilling planning responsibilities, the summer village will assess impacts on residents, the environment, and the economic viability of the municipality. You're thinking about how different developments will impact your financial resources. The third is that planning decisions will ensure the efficient use of land, infrastructure, and public facilities. The fourth is that the summer village will conduct planning activities in an open, consistent, and equitable manner. And the fifth is that successful regional collaboration and communication between neighboring municipalities benefits the region. So if we have good relationships with our neighbors, our lives are a little bit easier. Section 3 or part 3 provides the vision and goals for the document. In each section of the document, there's an overarching goal identified. And the vision that's included in the MDP right now is that the summer village is a quiet and safe recreational community committed to providing good governance and environmental stewardship. Fourth part of the MDP provides information about how the MDP itself is informed by other parts of provincial legislation. And that's just trying to provide a bit of an overview of where this is coming from, why this document has to exist, and what some of the other influences are that shape how municipalities manage land. And there are certainly other pieces of legislation that we do have to take into consideration that guide some of those municipal decision-making processes. And the fifth part talks about how this document is intended to work within the hierarchy of plans that affect land management within the province of Alberta and within municipalities specifically. So provide some information about the Upper Athabasca Regional Plan, the Intermunicipal Development Plan, other plans and bylaws that the municipality has, and then the Summer Villages Land Use Bylaw. Then we get into the stuff that's a little bit more interesting. So we like to, with our municipal development plans, provide a snapshot of the community today. So provide some information about what was going on in the community and has gone on in the community historically to frame the conversation about, what's appropriate for the community today. So we provide some information in these sections about the location and history of the summer village, the current population and demographic information, and then because you're a lake community and one of the most important resources or characteristics of your community is the lake, there's some information about the lake itself. And some of the information in this section, or most of it, is informed by the shoreline assessment that CPP Environmental did, because that's the most recent and up-to-date information that we have about the environmental footprint or characteristics of your community. So where sensitive environmental features have been identified, for example, wetlands, that information is included in this section too. And then it's mapped. At the end of the MDP, there's a map that identifies those areas that were identified by CPP through this assessment. And you can see it here. So that's map 2, environmental features. And on this map, there's information about riparian intactness, so that's the high disturbance, moderate disturbance, and low disturbance areas. Probably no surprise that the areas that have the lowest disturbance would be areas that are adjacent to environmental reserves or lots that are not developed or not developed to the full extent of their shoreline. And then there are some areas where there's moderate disturbance and a few more areas where the disturbance is a little bit higher. This map identifies one terrestrial habitat or ecosite, which is in the wooded area off of the lake. And then there is a watercourse identified and an observed riparian area around that watercourse that would be environmentally significant too, and a wetland also within your municipal boundary. So for a little community, you have a lot going on that it's important for the development officer to be aware of. And the development officer is also your CAO. So for your CAO to be aware of when new applications for development are received. And then each section, policy section of the document is structured to have an overarching goal, objectives, and then policies that are intended to help satisfy the objectives and the goals. So now I'll give you an overview of some of the policy direction that's in the municipal development plan. The first policy section is a general development section, and these policies are intended to apply to all of the land use areas within your municipal boundary. And they address things like erosion and sediment control measures during construction or development. And that's to try to minimize the amount of sediment entering the lake, because we know that this has a significant and sometimes immediate impact on water quality. Protecting wetlands and historic resources where they're identified. The requirements for things like conceptual schemes or area structure plans if new multi-lot development was proposed. That's a policy that we wouldn't anticipate. It's going to get a whole lot of that would be used very often by the Summer Village. Some of those policies, the ones that relate to higher intensity or density of developments, are there in the event that there was ever land annexed from the county to the Summer Village, which does happen from time to time. It's happened, we've been involved in 3 Summer Village annexations over the last 5 years. So it's happening a little bit more than it used to for all sorts of different reasons. So some of the policy direction in this document is there to, I guess, future enable or protect the municipality in the event that a boundary changed, not because we're expecting there to be a much higher intensity or density development be proposed within your existing boundary. Policies in this section also protect existing and regional infrastructure. They help to manage post-development activities on lots to prevent negative impacts on lake water quality and groundwater quality because they're related. We have some policy direction that talks about prohibiting large-scale agricultural operations or the keeping of livestock within your municipal boundary. You would think that would be, you wouldn't have to worry about that, but if you don't have a statement in there, you never know what might happen, and we've seen all sorts of things. We also have some policy direction that relates to prohibiting resource extraction developments within your municipal boundary, and then discouraging, because we recognize that there's some jurisdictional conflicts here, oil and gas infrastructure where possible within your municipal boundary, and working with utility and service providers to ensure that proposed infrastructure doesn't unnecessarily fragment land within your community. The next section is watershed stewardship. The policies in this section enable development and implementation of a fertilizer use bylaw. So this is something that we talk to council about, and the language is enabling, not requiring language, because it was something that council is interested in exploring moving forward. So if you have strong feelings about that one way or another, please do let council know. Policies in this section also require the preservation of vegetative cover on residential lots to the greatest extent possible. And the wording is really deliberate here. So it's recognizing that, if you're going to develop or redevelop a lot, the way that development patterns are occurring in recent years is that if a little cottage comes down, it's more often than not, probably 95% of the time, not being replaced with the same size cottage. It's being replaced with a larger cottage with a larger footprint. And in order to enable those larger developments to occur, there has to be some removal of natural vegetation. So there's a give and take here, right? And there's some flexibility in the policy language to enable modern development or redevelopment to occur on a lot, but still trying to preserve wherever possible that vegetative cover to minimize negative impacts on the lake itself. So where vegetation has to be removed, there's some policy direction to encourage restoration or reestablishment of natural vegetation. And then there's some policies that talk about designing subdivisions or development to conserve unique terrestrial habitats and significant treat areas which you have within your community. You're not a really complicated community. You have 3 different future planning areas. They're your residential development area, your commercial recreation area, and your community and environment area. And so there's 3 goals for these different areas. For the residential development area, the goal statement is that residential development will meet the demographic and lifestyle needs of your residents. Commercial recreation developments in the summer village support the needs of local residents and guests. And then the last one for community and environment areas, that lands that contain significant environmental features or are essential to the long-term health of Skeleton Lake are protected and preserved in their natural state and used for low-impact recreational purposes that benefit community residents. So no impact is not really reasonable. We understand that the reason folks are at the lake is because of the environment and the lake. And so we're just trying to ensure that we're minimizing negative impacts, again, to protect the lake itself. So that's what the map looks like, the future land use map. The majority of your community is identified as a residential development area. The areas where the reserve parcels are right now, of different types, are identified in the community and environment area. And then there's, I guess, one exception. That area that's identified by CPP Environmental as a wetland is also identified as community and environment area. Because doing development within that area is not something that would be beneficial for the lake or the summer village. So it's sometimes a little bit aggressive for us to do that within private land, but it was appropriate, I think, in this case. And then you do have that commercial recreation development area up in the north. So the last policy sections of the document relate to infrastructure and servicing. And there's policies that provide guidance relating to roads, water and wastewater, and then stormwater management. For roads specifically, the policies require direct access to municipal roads for new development or subdivision. They restrict the use of heavy vehicles, and they require that if a development were proposed that would be a higher intensity development and have traffic impacts, that a traffic impact assessment be provided. And the last one relates to working with Alberta Transportation to mitigate impacts on the highway. For water and wastewater, requirements for water servicing can be provided by individual systems. And mostly this is just a statement about, at this time, the Summer Village is not in a position to commit to a municipal water system. That's something that, if all of a sudden there was a random act of money that occurred and it was possible to revisit municipal water, this might have to be adjusted, but that would require a significant amount of funding for that to occur. Then the next one is just ensuring compliance with provincial regulations and requirements relating to water and wastewater as development and redevelopment occurs. For the stormwater management policies, the policies are encouraging rather than requiring, so the language is supportive of, but not restrictive, I guess, including low impact development design features in stormwater management facilities and site specific stormwater management plans to improve stormwater runoff and reduce risks of flooding. And really what we see, I think, in summer villages and in villages and in towns is that communities where the lots were registered some time ago, they were not registered with master stormwater management plans or with information provided to the lot owners about what their post-construction lot grading and drainage plans were supposed to be. So as those lots redevelop with larger houses, larger driveways, which means larger amounts of non-permeable surface, we have more runoff. and we have greater deviations in elevations between lots, which is creating conflicts, and it's creating instances of flooding as water comes off of the newly developed lot, either onto adjacent lots or into the municipal infrastructure. So we have to be really mindful of this. And it does require a little bit more planning at time of development or redevelopment to ensure that we're not creating inadvertently negative offsite impacts. So we know that it wasn't done the way that it probably should have been when the lots were originally created, and now we have to go back retroactively and fix that when redevelopment occurs. The last sections relate to implementing the plan and cooperation with our neighbors. So these documents do need to be looked at every few years. You know, you didn't think about how long it took to update your land use bylaw. I think if 5 years from the date of final approval, council sat down and said, how's the MDP working? Everything is still good, that would probably be the review in 5 years. But if there were problems with it, or there was language within the plan that was too restrictive or too enabling and creating conflicts, then it does ensure that there is that going back and checking in, and that the documents don't get stale dated, that we are addressing and making adjustments to ensure that they're living documents that reflect what the community needs. In terms of cooperation, that's the two main policy statements there just relate to working with other municipal and government stakeholders to support public education, conceptual design and development in areas, I guess, where there's mutual interest. And then collaborating with the Skeleton Lake Watershed Advisory Committee to create lake management opportunities between all of the municipalities within the watershed. And that's a statement that recognizes that, all of these things are more successful to implement, and we have the greatest amount of success, I guess, if everybody is working towards the same thing. Everybody is concerned about and interested in the lake, because it's why you're there. And the more consistency there is around the lake between the different communities in terms of approaches to land management and development requirements, the easier it is to implement those things. So that's the MDP. Land use bylaw is a little bit of a more painful read. Those of you who have had to work through a land use bylaw probably have had that experience in one capacity or another. Even Summer Village land use bylaws, which are much simpler documents than bylaws, land use bylaws for larger municipalities, they still have to cover, at least in the beginning parts of the document, the same things. So the administration sections and authorities and interpretation, which is definitions, the amendment process, development permits and subdivision applications and appeal process, and then even enforcement are very similar between different municipalities. The procedural requirements for how municipalities address applications and approvals and appeals are consistent throughout Alberta. So even though you are a small municipality and you don't have a ton of development pressure, those parts of the document are pretty comprehensive out of necessity. And some of the changes to those documents that have been proposed in the draft are, they increase the number of pages because we want to make these processes a little bit more transparent. And that's to make it a little easier for you as community members who are trying to figure out what the expectation is going to be of you at time of application, have a little bit more information about what to expect with conditions or that process so that you can think about your timeline and your costs. And then we also recognize too that in summer villages, just like everywhere else, it's a little bit difficult sometimes to keep track of your institutional history. So to ensure that over a 10, 15-year period, there's enough information and detail in the municipality's documents to ensure that when applications are coming in and being processed, it's consistent, the same things are happening. So the information that's in this draft document, which is a little bit more fulsome, is there for community members, but it's also there for administration too, recognizing that it isn't necessarily always the same person that's sitting in that chair. So just to try and improve consistency and interpretation. Where things get most, I think, customized or different for the different municipalities is in sections 9 and section 10, and then I guess also in the definitions too, and then the land use district map. So our focus for the conversation today is going to be, I'll go over pretty high level the admin sections, the procedural parts, but I want to spend the most time for you on those sections that are specific to the types of use classes or developments that you can do within your community to ensure that we're flagging for you those areas that will be most impactful potentially for you as a lot owner wanting to develop or redevelop your lot. So the first thing in the document is just a user guide. It talks about how land use bylaws are complicated and that you can't just look at one section of a land use bylaw. You have to look at different sections of the document to really understand what it is that you can do and what the procedural requirements are as you go through those different processes, so the development process. The next section just talks about the purpose of the bylaw itself, when it comes into effect, what area it applies to. Then there's a compliance and a severability clause. Part 2 provides information about the different roles and responsibilities of different organizations to implement and enforce the regulations in the land use bylaw. So who is empowered through the bylaw to make decisions? And then part 3, the interpretation section, has the definitions. And it doesn't matter how many land use bylaws I've worked on or how many times we've done this. This is where we end up spending the most time. In part because in the last 5-10 years, that's been one of the biggest changes we've made to land use bylaws is we've added more definitions. It is really difficult to consistently interpret the requirements in a land use bylaw if you don't know what the terms mean, or if the terms are so gray, everything's all kind of mashed together, that it is difficult to consistently have the same interpretation of what was intended in the regulations. So your land use bylaw had 35 definitions, which is, it's crazy. It's so few. And the draft has 177, just to give you, I guess, an idea of the scope of the change in that section. This is absolutely where we made the most significant amount of changes to your document. And it was really in an attempt to ensure that we were defining the terms that are being used in the document, so there's a clearer understanding of what's intended in those regulations and that they can be applied more consistently. In this section of the document, we've added a number of new graphics too to assist in interpretation. I don't know if any of you with us are lawyers. The lawyers and the planners often have different opinions about whether or not diagrams are beneficial for interpretation. If they're inconsistent, they're terrible for interpretation. But if they're consistent, it's an awful lot easier for us to be able to point to a figure to explain what we mean. We're trying to describe a double fronting lot versus a corner lot, for example. That's really complicated if you can't see a picture of it. Or even if we're trying to explain what we mean by lakefront lot versus back lot, it is helpful to be able to graphically represent some of those things. So there are a number of new graphics and diagrams in the document too, to assist with those terms that we know are not consistently interpreted and people struggle with a little bit, but do impact how you can do development on a lot or where you can do development on a lot. The next section just talks about how land use bylaws can be amended, because they can be amended and are amended from time to time. Some of those amendments are driven by council or administration. Some of them are driven by members of the community who want to do something different than what's allowed in the document. The process or the procedural requirements for dealing with an amendment are the same throughout Alberta. And this section's been bulked up a little bit to provide more information about those processes. Part 5 provides information about development permits. So this, I think, is the most pertinent administrative section for the types of things that will happen within your community. It talks about when a development permit is required and when it's not required. It has information about non-conforming buildings and uses, so how they can be used, continued, rebuilt, or repaired. And then it provides specific information about application requirements for development permits. It identifies a list of things that must be provided with an application, and then it identifies additional things that may be required depending on the specific site. So the types of perhaps environmental constraints that affect the site. Like if you have a lot that has a slope on it that's steeper than 15%, we're going to ask for a geotechnical report just to make sure that if you want to put a house with a basement at the top of it, the slope isn't going to move. So it's protecting you and your investment, and it's protecting the municipality from potentially approving a development that was inappropriate on that site because we didn't ask for information to ensure that it was. So those are the sorts of things that are May requirements, because they wouldn't always be asked for. They will only be asked when specific triggers are identified that relate to that site. And then the last bit there is some information about what would be required for permission for demolition. So generally, if it required a development permit to go up, it requires a development permit to go down. It's just to ensure that we're managing potential impacts on municipal infrastructure, that you're thinking about what's in that building that you're tearing down, and that the refuse is going to the right location, depending on what materials were in the building. We've had in the last couple of years situations where demolition has resulted in contaminated wells, contaminated soil, and then issues with gas and power when things haven't been disconnected properly. So it's important to think about these things prior to taking down buildings. The development permit section provides much more detailed information than it did before about notices for determining whether or not applications are complete, and this is because we have to include this information. There's also information about how notices of decisions will be provided and who they will be provided to. There's information about how those applications are processed, and then there's more detailed information about the types of conditions that might be applied with the development permit application. The control of development section just talks about when a development permit comes into effect. And it's different than the notice of the date of the notice of the decision, and that's because of the appeal period for permits. And it also provides the opportunity, I guess, for a permit to be revoked if it was issued in error, which does not happen very often, but I know of one in the last year that had to be revoked and reissued. Actually, I know of two. One of them our office was involved in. The measurements on the plan were not consistent with the actual dimensions of the house, and the landowner didn't notice it until after the development permit had been issued, and then contacted our office, and we had to revoke the plan or the permit and reissue a new one with the correct drawings once he caught it. So from time to time things happen, right? Sometimes municipality makes an oops, sometimes a developer notices an error in their drawings, and we have to work back in order to address those things and make sure that what's approved is consistent with what is intended to be and what is ultimately built on a lot. Last bit here relates to variances. So from time to time, someone will want to build something on a lot that is inconsistent with, I don't know, side yard setback, front rear yard setback. Sometimes someone will ask to build something that is greater in height than is allowed in the bylaw. We do from time to time as well get requests for developments that would exceed the maximum lot coverage percentage. In your land use bylaw, there are some limitations on the types of variances that will even be considered. The types of things that are identified as development variance requests where no variances shall be granted are things that relate to lot coverage, fence height. So max fence height is max fence height, and building height. And this is pretty standard around developed lakes. The reasons for the lot coverage limitations relate to trying to minimize the amount of non-permeable surface on the lot so that we're controlling the amount of sediment and phosphorus running off those lots into the lake. For fence height and building height, that relates to protecting views of the lake and managing privacy concerns on smaller lots and minimizing shadowing from new development into other lots. So these are things that would be considerations if you had a city lot I think the Edmonton's Matures Neighborhoods Overlay, there's some very specific requirements about these things. Some of our lake lots are similar sized lots to some urban sized lots now, and we have to think about the types of development that's occurring on them and try to manage those offsite impacts by controlling some of these things. And then in lake communities, the view consideration is significant, right? So that's in the draft now. I want to flag that one for you because that is a change as well. Now there is a subdivision section in the land use bylaw. We've been adding those the last few years because we have to put something in the document that talks about how we're going to provide notice of a deemed complete application. There is a regulation right now in the land use bylaw that says, and this was one that council wanted us to flag specifically for you tonight, no further subdivision within the summer village, which would increase the density of lots, will be allowed. So I'm flagging that for you right now, so you can think about that and then let council know whether or not you have concerns with that provision. It is not, it sounds like a really significant change. It isn't. The minimum lot size in your residential lot, I think it is, we looked at all of the lot sizes within the summer village, and there's maybe, I can't remember what the number is now, but it was very, very few lots that could possibly be further subdivided and still meet the minimum lot size requirement. So even though it's a bolder statement that was included in the land use bylaw than was there before, the minimum lot size requirement in the land use bylaw already prohibited further subdivision of lots except for like 5 lots. So it is certainly very impactful for those 5 or so lots that would be impacted by that provision, but that's it. Everybody else was already in a position where they couldn't further subdivide their lot because of the minimum lot area requirements. So just flagging that for you, let you think about that, and then let us know so we can let council know what you think about that. For the appeal process, this needed to be significantly altered just to reflect the legislative changes. Used to be that development permit appeals were only heard by the local subdivision development appeal board or intermunicipal subdivision and development appeal board if you had one. Now there are some types of development appeals that will go to the land and property rights tribunals. So that language needed to be added to the document. This is just making sure that your document is consistent with the legislation. So we've separated subdivision and development appeals and identified those triggers for identifying which appeal board is the right board. Enforcement. This section was tidied up a little bit to be a little bit clearer about what types of enforcement action are actually available to municipalities. So this section has been reorganized and reworded to be more consistent with those options. All municipalities are in the same situation. You get into a situation where a development occurs on a lot that has not been approved, either because it wasn't built the way that it was supposed to be, or development occurred without someone applying for the development permit, so it was never approved. And the municipality has to go through what is often a uncomfortable for everyone, long and expensive process to deal with enforcement. So there are violation tags that can be issued by the municipality. And there are violation tickets that can be issued if the municipality has a peace officer under the Provincial Offences Procedure Act. And then none of those things work to help sort out the problem on the property. A municipality can go through the process of issuing a stop order, which can be enforceable through the courts as well. So this isn't new. None of these things are new either. We've just tried to clarify what those things are and make sure that the wording is consistent with the legislation, and provide a little bit more detail about what these steps are that can be taken. Then we get into the last couple of sections, which are the ones that we have flagged the most areas for you to have a look at. On this slide, these are all of the general and specific regulations that are in your land use bylaw. They affect these different areas. The ones here that are identified in green are either new or significantly expanded or revised. And the areas where there's a red asterisk, those are ones that I've flagged in the slides that we wanted to point out significant changes in the regulations between the draft and what's in your current land use bylaw, so that you can provide council with feedback on those items in particular, in addition to anything else that you may have comments or questions about or concerns. So in regards to accessory buildings, I think over the last few years, there's been a little bit of confusion about accessory buildings. What can be built, in what order things can be built, and how they can be used. So the changes to this section have been proposed in order to provide greater clarity about what was intended in the previous bylaw, as we understand it, and what will be allowed moving forward. So this section has been revised a fair bit. There's some new figures that are included in the bylaw to provide greater clarity about where the building pocket is on a lot, and also provide a bit of information about what types of buildings will be allowed in the lakefront lots. So on a lakefront lot, interior or corner, the only type of development that would be allowed within 7.6 meters of that main building pocket is a special type of accessory building that we're calling a boathouse. I was talking to council a little bit about this earlier today. The definition of boathouse that is in the draft document right now is not the right definition of boathouse. It implies that it's one of those very old school types of boathouses with the doors that are oriented towards the lake, that are often dug into the bed and shore of the lake so that you can pull your boat right into them. That wasn't the direction that council gave us. That wasn't what they wanted to enable. This building that they wanted to enable in the lakefront yard, which is an area that we're trying to minimize the amount of non-permeable surface in, so that we can minimize the amount of damage to that riparian area adjacent to the water, is like a shed that you're allowed to have on that side to put your kayaks and your paddle boards and your life jackets and your kids' pool noodles and those sorts of things that you utilize at the lake in the water. So it's the terminology that we've used is boathouse because we wanted to distinguish it from other types of accessory buildings. But the purpose of enabling it is to try and ensure that you still have the ability to put a structure to house your water sport related equipment on the lake side of your property, just to make your lives a little bit easier. So it's trying to balance those two things, minimizing negative impacts on the lake water quality, but still enabling development to occur on that side of the lot that would, if you had to drag all of those things further down, it might be a bit of an impediment, especially for property owners who are a little bit older or have any mobility concerns. So that was the balance that we were trying to strike with that particular exception to the types of development that are allowed on the lakefront side of the lot. So think about that as you're reviewing the document and whether or not that makes sense for you. The other thing that we wanted to point out, a couple of things, I guess, is one is that there is a regulation now that says specifically that an existing dwelling is required before an accessory building may be constructed. The significance of that, I think, is if you are a property owner that currently doesn't have a cottage or a house on your property, you bring RVs to the property. This would mean that you couldn't build a garage on your property prior to the construction of your dwelling on your property or your cottage on your property, unless it was, cottage slash garage. And then we've definitely had some conversations about what is a cottage too, that are probably worth further exploring. But I wanted to flag that one for you because I think there are some property owners within the community that have one or two RVs on the property that may be impacted by this particular regulation. And so we need to make sure council has your feedback about that. Then the last one relating to accessory buildings that I wanted to flag is about maximum height for accessory buildings. So one of the things that council was thinking about is, is 15 feet a reasonable height for an accessory building in this day and age, considering what they look like? And should that height be expanded in order to allow for a larger accessory building? And then we had a conversation about how this might impact viewscapes and shadowing and privacy and all of those things. Then the compromise position was to allow for larger or higher accessory buildings on back lots where you're set back from the lake, but to keep the 15-foot maximum height for accessory buildings on a lakefront lot. So we're flagging that one for you too to think about and provide council with your feedback. So boathouses, and just taking into consideration what I said about us needing to revise that boathouse definition because it's not the right definition. This has been separated from the other accessory building regulations because we wanted to enable there to be a small accessory building in the lakefront lot to allow you to store water sport related equipment. There are restrictions or design mitigations that go along with this to try and minimize the amount of runoff coming off of the roof of this building to I guess negate the potential negative impacts on the lake. So the maximum number of them that you can have is 1. There is a maximum size identified for them, so 10 square meters. They still have to be set back 6 feet from the property boundary or 1.8 meters, which is pretty close to the property boundary. They can't have sleeping accommodations within them. And then there's some design mitigations to try and minimize impacts on the view of the lake from the adjacent properties. So they need to be low sloped, so 312 or less to minimize view obstructions. And then there's a requirement for the gutters, there to be gutters on all sides of the downsloping roof that collect the water and then drain it away from the lake. So it has to pool on the property before it goes into the lake so that it can be absorbed into the ground, and that's to reduce the amount of runoff. And then where possible, we've indicated that they should be built on piles or skids, and that's just to allow the water to continue to flow underneath them. So that's new, just flagging that one for you too. Fences and walls. Okay, we had lots of discussion with council about fences. The fence provisions in the existing land use bylaw were a little interesting and a little bit difficult to interpret. And so even trying to figure out what was allowed versus what's been approved in the community over the last little while was an interesting exploration. They were not consistent. So we looked at what the existing land use bylaw enables. It is not consistent with what's been approved historically. And so we had to then think about, well, what do you want to see moving forward? And what are some of the potential challenges with continuing to allow some of the things that were allowed, even though they weren't supposed to be allowed over the last little while? And then what other changes maybe should be necessary in order to preserve views of the lake? So the two, I think, most important changes in this section that we wanted to flag relate to there being a maximum height for fences on the road side of front and back lots within 6 feet of the road property line. And so what we're trying to do is enable a higher fence on the road side, on both sides of the road, but not allow it to be 6 feet all the way to the road, because we recognize that you guys use your roads as your pathways and pedestrian corridors too. So if those 6-foot fences went all the way to the road, it makes it really dangerous for people as they're backing out of the property to see who's walking on the road or biking down the road coming from either direction. So the purpose of this provision is to try and give you some privacy, or if you have pets, enable you to have pet fencing, but still ensure that we're not creating a traffic safety hazard. So that's a change. And then the next one that I think is important is that there's specifically a restriction from that doesn't allow fencing along the lake front of lots. And that's to minimize visual impacts on the lake. So the current regulations allow fencing on a back lot. The fencing right now, it can't be greater than 3 feet on the roadside on a back lot, but on a lakefront lot, it could be 6 feet all the way to the road. On the lakefront today, it can be a maximum of 3 feet on the lake front, so from the main building forward, and it can go all the way around, but you can't have any 6-foot fencing past where the main building is in the lakefront side to restrict, to minimize visual impacts. On the new or draft bylaw, the change is that on rear lots and lakefront lots, both lots can have some 6-foot fencing in the roadside yard, but it's restricted within that 6 feet of the road. And then it specifically states that no fence along the lakefront of your property line. So that's the biggest changes we wanted to flag for you as you're going through your review. There's a new section that provides information about landscaping. It indicates that the clearing of vegetation for lake access requires development permits, in part because we want to make sure that you're not clearing land that you don't own. So make sure that's all sorted out. Development permits are required for landscaping that alters natural drainage or alters runoff towards the body or water course. Specifically, we're talking about the lake. And where development permits are required for landscaping, you need to submit a landscaping plan. So if the development authority is trying to figure out what it is that you want to do and then have a record of what it is that's approved, so if we have to deal with enforcement at some point in the future, then we need to have a drawing that shows what it is that was intended and what was approved. Otherwise, we can't deal with enforcement down the road. So it doesn't have to be super fancy, but it has to be something that addresses the requirements within the section and is to scale enough that it would enable appropriate enforcement in the event that something shifted in the future and the Summer Village had to do enforcement. We looked at, I was saying, all of the lots within the Summer Village to try and ensure that when we were identifying maximum parcel coverage percentages, we were identifying something that would be appropriate and achievable, taking into consideration the style and type of construction that people are proposing at the lake. So in the requirements that relate to parcel coverage now, we were factoring that in. Where there's a big change here, I think, relates to now identifying not only a maximum site coverage percentage for buildings, but also requiring a maximum lot coverage percentage for non-permeable surfaces. And this is something that we've been working with different lake communities on throughout Alberta, because it's one of the easiest most impactful design mitigations that we can implement to protect the water quality of the lake. The more non-permeable surface there is on a lakefront lot, the more direct runoff into your lake. And that has one of the most negative consequences for maintaining lake water quality. So in the residential district, we've identified a maximum lot coverage for buildings of 35%, maximum lot coverage percentage for non-permeable surfaces. So that would be driveways for the most part, although I guess there's some concrete patios that would be included in that. That's the 10%. And then a minimum requirement for vegetation and tree and shrub cover on a lot of 30%. And it may seem like this is more information that we need to require than we would need to provide somebody that people would do this anyway at the lake. But we've seen in recent years people coming in, clear cutting the entire lot, building very, very large houses on the lot, and then covering anything that is on the roadside in asphalt, so non-permeable surface, and then applying, instead of planting trees and shrubs and grass on the lakeside, because they're only going to be there sometimes, putting down turf. So we've absolutely seen development at the lakes that is very different from the type of development you're used to at your lake. And if we don't have some requirements in the land use bylaw that try to preserve the character of your existing community, then in the event that someone comes in and that's their vision for their lake lot, the Summer Village wouldn't be able to say no to it. So this is one of the things that we've done to protect lake water quality as best we can, but also to help preserve your existing character and community of your lake community. So think about this one too, and think about what your development plans are on your lake lot and whether or not this is something that you can work with, or if this would present challenges for you. And if you have any questions or concerns about that, please do reach out to us, because I think this is probably the most complicated of the changes, but also one of the more important changes to the document. 9.12 talks about tree removal, provides some information about and restrictions for how many trees or the types of tree removal that can occur in a lot that would trigger the need for a development permit, and those that wouldn't, like regular tree maintenance, dealing with deadfall, those sorts of things don't. But we're trying to ensure that there's enough regulation in the document to prevent the clear cutting of residential lots, and then having to deal with the negative consequences of that. Guest house suites. So your current land use bylaw is really confusing to understand on this particular topic. And this has resulted in some real challenges, I think, for property owners and for the summer village in understanding what's allowed with guest houses. So we've tried to provide a little bit more language regarding this particular item to clarify what our understanding of the intent was with the previous bylaw so that it's clear for everybody. The proposed regulation in this section is that guest houses are just prohibited. And what a guest house is an accessory building that has a kitchen, bathroom, and bedroom in it. So that it's that clear. If it has kitchen, bathroom, and bedroom, it's a guest house. Doesn't matter if it's in a garage, above a garage, or in a standalone building. And you've already got a dwelling on your property. The next one is considered a guest house, and it's not allowed. So this is one that council needs to hear back from you on too. This is one of the ones that they identified as us important for us to flag for you. The current draft says no guest houses. If you had an accessory building on your property that had bunks in it that your kids or grandkids stayed in, it is what it is. That's not something that is restricted in this land use bylaw. I assume that at the lake people will have things like that. It's fine. This is just kitchen, bathroom, bedroom. So second house, second smaller house on the lot isn't allowed. Recreational vehicles. Your current land use bylaw is really silent on this too. So we've tried to provide a little bit of greater clarity around what would be allowed. And what's been proposed, and we need your feedback, is that on a lot that currently has a dwelling, so cottage or house, a maximum of 1 RV may be stored on the lot without a development permit. On a lot without a dwelling, maximum of 2 RVs can be stored on a lot without a development permit. 1 additional RV can be stored on a lot up to 4 days without a development permit if there's sufficient room on the lot for the RV to be located. Anything over that would require a development permit. And then RVs must be located entirely within the boundaries of the lot. They can't poke out into the road right away. And RVs sited on a lot on a permanent or quasi-permanent basis have to be connected to an approved private sewage disposal system. So it's probably what we're most concerned about really with RVs is that we're managing private sewage, and then that we're managing noise associated with generators or things like that on adjacent properties. So please read those sections in detail and provide council with your feedback about that. And you can send your comments to our office or you can send them to Kim, and we'll compile all of those things so that we can get that feedback back to administration and council. CCANs, these were not identified specifically in your land use bylaw, but these are things that we get inquiries about. So now there's regulations that talk about the placement of a CCAN on a lot, and they would require a development permit. The way that it's written right now, there's some aesthetic requirements, so where they can be situated, and the ability for the development officer to require some cladding to approve their appearance. And then there's a maximum of 1 CCAN will be allowed on a lot, and you have to comply with the minimum lot coverage percentages if you're going to place one. The next one is tourist homes. And so certainly in 98, this wasn't something that we were thinking about at all. So that would be Airbnbs, those sorts of things. So the land use bylaw is silent on this because it wasn't a use that we were contemplating. Now it is something we got to address one way or another. What is being proposed in the draft is that tourist homes will require a development permit. Development permit will be for 12 months. So you can see how it goes. They can't be located within an RV tent or tented structure, so no yurt tourist homes within your summer village. They can't be within an accessory building either. You can't have a second kitchen, bathroom, bedroom. We've identified maximum occupancy requirements for tourist homes. Essentially, the way that calculation would work is that be the number of bedrooms times 2 people, up to a maximum of 8 persons, with no restrictions in the number of kiddos under 12 that would come with. Think about that too. If you are someone who has a tourist home or considering it, or uses tourist homes, Airbnbs from time to time, is there anything about that that's problematic for you? I know I have a kid who just turned 13 in our house, and we and our friends regularly go on a trip a year where we Airbnb. And so it would be 3 families, 4 families, and 2 kids each. And now that I have 13-year-olds, that would be a problem. So think about those things. Think about those things. Then the other bit there is just that they have to have enough sufficient parking to accommodate the visitors that would be coming on the site, and because we're trying to minimize the offsite impacts. Okay. Those are the ones that through our conversations with council and administration, they flagged as potentially, I don't know how the community is going to feel about this. We may need to rethink some of these things. Maybe we're doing things absolutely right. We're really looking for some feedback from the community before we get into finalizing this. There may be other areas that you, as you do your own review, have flagged as, I don't understand what this is intended to do. There's a conflict, or this is a problem for me, and we really want to hear from you about any of those areas. Or if you like the direction that some of these changes are going, that would be beneficial for council to hear about too. The last bit of the bylaw is the land use bylaw map in the districts. We did not change the land use bylaw map. There's a residential district, a public recreation district, an urban reserve district, and then a commercial recreation district. So we just tried to keep the status quo in regards to those things. The changes that we did make relate to specifically the ensuring that the language in those district provisions, the uses reflected the new use classes and terms that are identified in the definition section. So trying to improve the consistency between the language used, the new use types, and then what's identified as permitted or discretionary uses in the districts. So not a whole lot of change in those sections, except that the words are a little bit different to reflect the new definitions. Yeah, so that is in an hour and a half, a high level overview of 2 great big documents. It's a ton of information. And if it's a little bit overwhelming, I apologize. Tried to go through it as succinctly as possible, but it still meant you had to listen to me talk for an hour and 33 minutes. So my apologies for that. Thanks, Leah. Next steps, we really, really, really encourage you to have a close read through these documents. The MDP is not painful. It's actually kind of an enjoyable read, municipal development plans. The land use bylaw hurts a little. It is the longest bylaw that a municipality has. And even when you're a little municipality like this, they're a little bit painful to read. I know one of you has done this a few times before, so I'm gonna ask Deb that you look at that closely for us. And if you have any questions, please reach out. Please send your feedback to Carly. Carly will get that to me, and through me, we'll send it to administration and council. If you're more comfortable reaching out to the CAO or to council, you can do that too. But ultimately, it's got to get to us so that we can compile it. We'll compile it by topic, and then we'll provide some recommendations to council, and then that'll go back to council. Summer Village has a really nice website, very nice for municipalities this size, and lots of information about this project on the website. So stay tuned to that for updates on this so that we can provide you with information about the timeline for the next steps. I know that council would really like to have this done by the end of the summer. I think they would have liked to have had this done at the beginning of the summer so that you guys had this in place for your next construction season. But I think realistically, we need to give you a little bit of time to look at these documents, to provide us with some feedback. I'd like to give you a couple of weeks to do that. Yes. There's a question in the chat that is, are we allowed to ask questions tonight? You totally are. Give me 2 seconds and then we'll unmute you. And then if you have any questions, maybe we can do that. We're a small group. So I think maybe that's the easiest way to do it. We'll just have a bit of a conversation if you guys are comfortable with that. And then anyone who has any specific questions, because you've had a chance to look at it, be happy to answer those questions too. So over the next little while, for those of you who haven't had a chance to, please have a look at the document. We'd ask that you send any comments or questions that you have. We could get that back in the next 2 weeks. So what is today? Today is the 3rd. 14 days from now would be the 17th. So around the 17th. That would be helpful and would allow us to keep moving along here to try and get this done before you guys are away from the lake and not thinking about the lake as much. And then we'll go from there. So I'm going to ask you fine folks to unmute. Only unmute if you want to. You don't have to, but I'm going to enable you to speak so that we can have a bit of a conversation. There we go. So you should be able to if you'd like to. Deb, do you want to go first? Hey, Deb.
Sure. I have a couple questions. Gather them here. I see a lot of information on enforcement, of course, in the land use bylaw, and I'm just wanting to place this out to the council. It's fine and dandy to have all of these land use these bylaws on municipal development plan, and particularly the land use bylaw. Are they prepared to enforce the land use bylaw? And if so, how?
That's not a Jane question.
I know it's not. I'm just throwing that out there to council. It's all nice to have all of these regulations, and I lived and breathed land use bylaws all my career. And I just want to know what enforcement, because it's gone complete deaf ear up to this point. Because there's one particular lot and all of this council knows which lot I'm talking about, has like 5 RVs and 15 buildings on it, and all their construction equipment from their company. And I just want to know, is there enforcement? They broke the old land use bylaw and they're breaking it now. So I think you need to think about that enforcement, because it's no point having rules if you're not prepared to enforce it. I was also wondering if there's anything going to be addressed in here relative to mooring or disturbance standards. I know that that's a provincial requirement, but there are public lands. It used to be called municipal reserve, and now I see in the land use bylaw, it's public lands. Is there any process that's going to be identified in the land use bylaw relative to personal docks on public lands?
I can't answer that one, Deb. We've been
No.
keeping mooring standards outside of land use bylaws as a separate policy thing in summer villages and the counties too. Kim, have you guys started working on docking and mooring standards?
They do already. They had one in place before I started, and I have not gone completely through it yet. So I'm not sure if we have to do any more work on that or not.
And did the summer village do that by bylaw or by policy, or do you know what that is? And is it something that's on your website?
I believe there is a bylaw. Give me 1 second and I will check.
Thanks, Kim. So separate from land use bylaw, but it exists, Deb, and we'll get that to you to have a look at.
Okay, yeah, because in the land use bylaw under section 9.17, it does talk about adverse effects. So it talks about sight or smell. And certainly I know that our neighbor who's trying to rent their lot has had a lot of problems because of the adverse effect the lot next to them has. And that's unbelievable. And everybody on this council knows exactly which lot I'm talking about. So
is that a docking and mooring standard thing though, Deb, or is it just?
No, that one is not. That's the 9.17 is adverse effects that I'm talking about. And the docking and mooring, the mooring standards, I know that the council told me that they had some 5-year agreements with some personal docks that it's like where their playground is. It's a playground that's abuts the lake. And there's a bunch of personal docks there, and I'm just not sure if they've got those agreements, and if they are, they're going to keep maintaining them. And if they are, how are they? Is there any standards around those requirements on those docks? Because some of them are not really being kept in very good condition. And
are you talking about the docks that are over on Lakeview Park?
I'm talking about the ones, let me see, we're right close to the where the boats dock. The boat
Like the
lift.
boat launch.
Both launch, yes.
Oh, okay. As far as those ones and the ones over in Lakeview Park, we've been following the provincial mooring standards. So the applicant has to send in an application to, I believe it's Transport Canada, or yeah,
No,
something like
it's
that.
to the province. It's to the
Yeah.
province, and there has to be,
Whatever division it is, and then once they get the permission from them, then it's sent to the CAO, and then the CAO was giving a permit for that spot for, I think, 5-year permits.
okay, well, they're supposed to be within a 50-foot lot, one dock, and that's certainly not the case. So I suggest possibly you look into those standards a little bit closer. I, I actually was on a committee with the province on this, so I think that maybe some more work needs to be looked at in that regard. That's
It is
all.
all really-
And it's not a big
really
deal. There's 3 lots within 3 docks within a 50-foot lot. And they're all, some of them are fine, and then there's others that are in quite adverse of, like, they're not nice docks, and there's weeds growing up, and I don't know if anybody looks after them. Some of them are left out all winter. So anyway, it's just something to look at. And I was told that you have agreements with them, and once those agreements are up, then you'll be looking at some other, but it's all about enforcement again. You know, that's the biggest thing. I mean, I worked for a municipality for too many years, and and I know enforcement's always an issue. So it's no point putting regulations in if you're not prepared to enforce them. And I think that that needs to be looked at, because, you know, I mean, I just built onto my cabin. I got all the permits, everything I was required to, and the neighbors are building something, and they've got nothing. I know that because I've checked your website.
What lot is that, Deb, so we can look into it?
What lot?
Yeah.
No, you know which lot,
Maybe
I can
don't-
send it to you.
All right, maybe don't talk about that on a recorded.
Yes, I'm not going to talk about that. I can send it to Kim.
Okay.
Anyway, that's all. I was just talking about enforcement, the adverse effects of, and it's sort of like an unsightly lot, but it is actually addressed in your land use bylaw here. And I really do agree with your guest houses. I think that's great. And I like that you're allowing, you know, like at least one recreation vehicle on a lot. You know, I know my sister has a lot at another place. They prohibited any recreation vehicles, and that council was ousted the next go around, and it ended up turning around. So you guys are being very fair in what you're looking at on recreation vehicles on lots where there's either no primary dwelling or a primary dwelling. So I'm really happy with what I saw there.
Thanks, Deb. Okay. Did anyone else have any questions or comments right now? I don't want to put you on the spot if you're not ready yet. You still have a couple of weeks to get some feedback to us. And I guess my last request, I'll plead with you. Please make sure your neighbors know this is going on. The worst scenario for all of us is that we have, you know, 30 people show up at the public hearing that had no idea this has been going on for the last couple of years, and they're all really upset, and they're afraid we've been trying to pull a fast one on them, which we are totally not trying to do. We really want the community to be engaged in this and to provide us with your input so we can make sure that this is addressing the things that have been problems for you, and is not, you know, creating problems for you. So it's helping you continue to enjoy your beautiful community the way that you are today. As much as is possible, while still trying to make some adjustments or improvements that will protect your lake. So that's something that we got to be thinking about when we're talking about doing development in a lake environment. I have had people say in the past, you know, it's just the lake. Like, why is this so complicated? And my response is, it's the lake. It's really complicated. Is if you want to build in a beautiful environment, it's beautiful because you have these environmentally significant or sensitive features, and we need to do our due diligence and look out for them and look out for us, because it's always a little bit harder to develop in those areas too. So was there anything in the chat, Carly, that I missed? No, we're okay. Okay, then I kept you for 1 hour and 45 minutes. Oh my goodness, you guys are all saints. Thank you so much for tuning in with us tonight. We really appreciate that you're here, and we're really looking forward to hearing more from you. Yeah, have a wonderful evening. Really nice to see you, Deb. All right, you guys, you take care. I will stop the share, and we will end the recording, and then we will end the meeting. Oh, yep.
My husband is trying to ask a question for Wes Clark.
Okay,
and he's
okay.
heading through. Maybe I can just grab him and pull him up on my screen.
Yeah, do you want me to see if I try to ask Wes to unmute again, maybe that'll work?
Okay,
Wes, do you want to try again?
Yeah, no, that works now. It's just
There
I
we
was trying
go.
to unmute, but it wasn't allowing me to, just because the
Sorry about
host
that.
thing. No worries. No, I was with Deb. I was just kind of inquiring. I don't know whether we're gonna get it answered on this go or it'll be answered later on. But yeah, on the doubling down on her, who's looking after and enforcing those development permits? Like, is it a bylaw officer? Or is it our administrator? That's what I'm gonna kind of key on as well. It's all fine and dandy with a lot of bylaws, which is good, and to have good guidelines, but just enforcing is also, I'm just gonna put a key out there.
I know we've talked about this before with council and administration. I can't remember. Do you guys have a peace officer on contract at all, or does everything happen through the CAO?
No, it's just me.
So it's Kim. Poor Kim is responsible for all of the enforcement. So in my experience, one of the launching of a new land use bylaw things that tends to happen is a little bit of enforcement. It's the next step, right? As you go through what is an incredible amount of work for council and administration and the community when they're involved in this. It does result in changes being made. And as we're having those couple of years of conversation, things come up, right? Like you find out and have conversations about these things. I see you, Deb. And then you got to take some action to deal with some of those things. So I don't know that we have had that conversation, Kim. Kim is relatively new to the community, right? But my expectation is that some of these things that have been difficult to deal with from an enforcement perspective in the past, we need to be working on dealing with as part of the implementation of the new bylaw. So that would be my recommendation to council and administration. We haven't had a big chat conversation about it before, but I think that is a good time. So. Deb, you had another one? Yeah.
I was just going to suggest that, it's always good to speak to with your neighbors. I don't know what the Village of Boyle does for their enforcement and if they contract out the county's peace officer or what, but it's worth having that conversation with them. And there's like a whole pile of stuff relative to speeding and all that. It has nothing to do with this, but I think that it would be really beneficial and the people are would be quite receptive to having some kind of enforcement, not just through the land use bylaw, but through other highway traffic issues as well. That it's worth looking at and I think tax is well spent, in my opinion. So for safety as well.
I don't know if the summer village has ever done that before, but that is something that's really common for summer villages, right? Yeah. Hopefully I'll try to get you so you can unmute too.
Yeah, and I think Kim looks after other summer villages, and I was the executive director for the Summer Village Association, and I know that there's lots of resources out there to draw upon to ask them, your colleagues, what they do for that enforcement side of things. And going through the association, they do a thing of putting out questions to the rest of the whole all the summer villages. So it's just using those resources to find out to get some ideas on how to help you with that enforcement side of things.
I just wanted to let you know, Deb, that for every year we do talk to the RCMP and let them know that we wanted to come through. We phone them, we talk to the person. We've actually had them come out to our AGM before, but also I don't know if it was last year or the year before, I spent, I'm going to say, hours and hours and hours and many meetings of many different places and trying to figure out how we could get some sort of peace officer or law enforcement that was affordable to our tax dollars. And I was not able to find a solution to that. It was all too costly, really costly. So if there is anything new that I'm not aware of, I would love to know about it, because that was something I kind of had taken on early in our, I know, Lawrence, you weren't part of that, but it was before your time, but with April, because I looked at partnering with other communities. I looked at, it was.
Yeah, and it's it's contract. You'd have to, I mean, the Summer Village.
It was contract out. That's
you'd
what
have to contract to, maybe, like I said, the Village of Boyle might be contracting some services. Maybe you can afford one day a week or whatever to, because you can't afford to do it on your own. You have to contract.
It's not that simple. We've done we've contacted Boyle. It's not that simple, I guess. And that's a bigger conversation than what we have here. But it is something we have definitely looked at and will continue to look at, and we could look at it do another deeper. If you have any ideas, then please send it to our council email as well, because if it's something we haven't explored, I would love to take that on, and we could, or divvy that between the three of us,
Yeah.
because it's something we would like as well.
Yeah, and otherwise your CAO is the one that's going to send these letters. If I'm speaking from the land use bylaw perspective alone, your CAO can send letters. They're authorized under the Municipal Government Act, and then they can follow up. And but it's lots of work, you know. And does your CAO have that time? And sometimes just the start of a letter will scare some people, right? But if you are going down that road, you have to be prepared to complete the road, because if you send a letter to scare and nothing happens, that word gets around real quick too. So just a comment. So anyway, thank you for listening.
Thanks, Deb. Anyone else? Anything else? Sorry, I almost cut you off there, Wes.
No, it's all fine. No, I was just inquiring about just the same thing as Deb. They're just wondering who. And does NPS ever help out with areas to help, I guess,
With enforcement?
guide enforcement sort of thing?
Enforcement's the worst. No. It is the absolute worst. And like, really, I agree with Deb, totally understand what Leah's saying in terms of how complex and expensive it is. But the best case scenario is if you can get, 8 hours a week from a peace officer that's shared throughout a region, kind of thing. Because it is
Tried. And we're willing to try again, but I really do want to let you, I've spent so many hours in trying to make this happen. But we can definitely revisit it. 100% we can revisit it, because things do change.
Right.
And I do think enforcement is one of the biggest challenges for smaller municipalities too, in part because it's so difficult to access a peace officer. And then if you can't access a peace officer, then you don't even have the same range of enforcement tools as municipalities that have one, because you can do tags, but you can't do tickets. And then you just have tags and you have stop orders, and stop orders are expensive to enforce because you have to end up going through this whole process, right?
And you need a lawyer. I mean, legal can do all of this for you too, but you have to pay. Have you looked at other municipalities like Thornhill County, who has already a peace officer that looks through Long Lake?
We did. I phoned Thorhild. I phoned Lac La Biche.
Okay.
We talked to Athabasca. Athabasca even hired a new bylaw officer. But the thing is, all the summer villages in Athabasca County get those guys as well. And every summer village wants them on the weekend when all the quadders and dirt bikers are out. So it really left like a Tuesday morning kind of thing. And it was like, that's probably the time that the least stuff happens in our village, right? So, and the cost was exorbitant, dealing with Athabasca County's bylaw officers too, but Thorhild wanted nothing to do with it. Lac La Biche wanted nothing to do with it. So, and they even said that their cost would be too much to really make it feasible for them. But yeah, we've contacted other counties.
And that's the police are really more on the speeding and stuff. This land use bylaws are more where the CAO and legal counsel gets involved, right? They do inspections, you have to do stop orders, you go through the courts, you can issue fines, but you're limited on the fines. And fines I don't find are that effective. You need to do enforcement. So, and that brings up, you don't need RCMP or special constables to do that. Your CAO and legal has to do that.
Yeah, and it's expensive and takes forever, and nobody's happy at the end, but it's the only way to resolve those land use bylaw infraction things, unfortunately, if the politely worded letter doesn't work. And sometimes it does, sometimes it does. But sometimes it doesn't. Yeah. So.
Well, our new CAO is on top of things, so I'm sure it'll be a difference coming up. So
in the existing bylaw, after a development permit is issued, or someone applies for a development permit, the CAO has 40 days to respond to that application.
So the that's yes, but yes and no. The way that it works now, because there was some changes in the legislation, is that when you drop off a development permit application or email a development permit application, the municipality, so that the development officer, who in your case is your CAO, has 20 days to deem it complete or incomplete. So they have 20 days to figure out whether or not they have everything that they need in order to be able to process the application. Sometimes it's really quick. We can figure it out really quickly and easily. I don't think I've ever seen one come in that was complete, ever. So generally there's a little bit of back and forth to try and get the things that we need to deem it complete. Nobody waits 20 days, unless it takes 20 days to get all of those things. You go as quickly as you can. So you have those first 20 days to figure things out. As soon as you can deem the application complete, you deem the application complete. Once the application is deemed complete, you have 40 days to issue a decision for a development permit. Same sort of thing in a small community. You're not waiting 40 days. You're not just sitting on it. You make the decision as quickly as you can. So in our office's experience, the big lag in time for issuing permits tends to be just how long it takes to get all of the information you need to be able to deem the application complete. Once the application is deemed complete, generally the decision is issued within 48 hours. Like, you have what you need to go ahead and do it. The only times there's weird little delays is if the municipality has very strange notification requirements for the issuing of development permits for discretionary uses. So if you have to provide notice in the local paper, then things can get all buggered up with the timeline, because you have to think about when the paper's notice, like paper's publication date is. And your land use bylaw doesn't have any of that stuff, so there isn't any of those things. So they have a maximum of 20 days to deem complete, a maximum of 40 days to issue a decision. It would be very rare, if things were going well, for it to take that long for either of those things to happen. I don't know what your experience has been in the past, but I know Kim moves things along as quickly as she can.
And I think that the biggest issue is not the development permit application, it's those that don't apply, if what I've seen around, because I check the village website, because they do put their there's all kinds of stuff going on there. They don't make application for anything. So that's where I think the big issue is not once you apply, but it's those that need to apply that aren't. So
I agree. I've seen that same kind of stuff too. So it's hard to grasp everybody at the same time, but we're trying, and hopefully with bringing this new land use bylaw in, and we can get a good grip on it. And now Kim is informed because she's been on this now with us for a couple of months. So she'll be on top of it. It's
one of the other challenges, I think, too, just speaking openly, right, is that at the lake, you're out there for the summer to enjoy yourselves. And all of these horrible things happen at the summertime, while you're supposed to be out there enjoying your lake time. And so it is a bit of a nightmare. It's really hard for council in particular to be trying to be at the lake and enjoy the lake and also deal with all of these things. So it's more difficult for summer villages than for other places where you've got the whole year to deal with these things. All this mess of things that happens during your vacation time. You guys, you're saints, man. Okay. All right. Well, I'm going to let you go. I've kept you now for almost 2 hours. Councillor Administration, anything that you wanted to add before we close, or shall we close?
No, just thanks, Jane. That was a great recap.
Awesome. All right. Well, thanks, Kim. Thank you, everybody. Please don't hesitate to reach out to us. You've got Carly's email there. We'll make sure that the contact information is also on the Summer Villages website. And then, yeah, we're looking forward to hearing from you as we move through the next couple of months here to get this complete. So have a wonderful evening.
Thank you.